person working with me today. All right, we're here to meet with Mr. Dwight Lowan, who is the Commissioner of the Department of Worker Claims in the Commonwealth of Kentucky, and he is going to be talking with us today about worker claims and the process of worker compensation when a person has a work-related injury. And as always, this will be informal, and if you have questions, certainly raise your hand and we'll call on you, and you can ask your question, and Mr. Lowan will address it. And many times that's a good way to address or to identify areas that people are thinking about and might not otherwise come to Mr. Lowan's attention. So if that's okay with you, right?
Absolutely.
Okay. All right, so I'll just turn it over to you, and I'll be right back.
Okay. And I am a big fan of questions. I prefer that most of the questions tonight relate to workers' compensation and not to other topics, since I don't know much about anything else. My name is Dwight Lowan. I'm the Commissioner of the Kentucky Department of Workers' Claims. The Kentucky Department of Workers' Claims is the state agency that is charged with the responsibility of overseeing the Kentucky Workers' Compensation Program. My background is that I'm a graduate of Baylor University from a long time ago. I went to the Air Force for a while, came back and went to the University of Kentucky College of Law, left here, left UK and went to work for the Kentucky Court of Appeals as a workers' compensation staff attorney. I had taken a course in workers' compensation when I was in law school, but I didn't necessarily think I was going to end up in that particular area of the law. Just by happenstance, I went to work for the Court of Appeals. I did all the workers' compensation appeals, or all of them went through me. The judges actually decide them, but they went through me. I worked there about 15 months, went to Owensboro, where I went into the private practice of law, doing primarily, almost exclusively civil litigation with an emphasis on workers' compensation. I also did a lot of civil trial work, personal injury, things that you'll run into. I ran into a lot of vocational experts along the way, and learned a lot about that particular program as it relates to what I do. I know y'all are in rehabilitation. I assume it's vocational rehabilitation, since that's Dr. Crystal's area, and I've had interaction with him both as a workers' compensation judge and also as an attorney. Practiced law there in Owensboro for 11 years and got appointed as a workers' compensation administrative law judge in Kentucky. We have 16 administrative law judges who travel all over the state deciding all the workers' compensation cases. My office was in Owensboro, but we have 12 different hearing sites. I had as many hearings, probably had more hearings, more dockets in Hazard than I did in Owensboro, simply because of the nature of how workers' compensation works in Kentucky. Did that for 4.5 years or a little bit longer, and then I was appointed to what's known as the Workers' Compensation Board, which is the first step in the appeals process in workers' compensation. It's like a workers' compensation appeals judge, and there's 3 members of the Workers' Compensation Board. They're the first step on all appeals in the workers' compensation world in Kentucky. I keep emphasizing that, and I'll talk to you more about that in a little bit. Spent 9.5 years there, went back to private practice for about 4 years, and then a little over 4 years ago, about 4.5 years ago, I got appointed to this job, which is the commissioner, which is sort of like the CEO of the program. My responsibility is for the entire program. We have a nice facility there in Owensboro. You're welcome. I mean, not in Owensboro, I keep saying that. In Frankfort, you're welcome to stop by sometime and visit with us. And so that's my background. As you can tell, I've spent a large portion. Nowadays, I've spent over half my life working in Kentucky workers' compensation, which is a pretty frightening thought when I really think about it, because you don't necessarily know where you're going to end up when you're leaving school. I find it fascinating. I found that workers' compensation is sort of a microcosm of the Kentucky world. You learn a lot about vocational rehabilitation. You learn about vocational testing. You learn a lot about medicine, because you have a minimum of 4 doctors testifying either by report or by deposition in every case. So if you're going to do this very long, you learn a lot about that. There's a lot of socioeconomic issues, because when you're considering whether somebody has an occupational disability, you take into consideration their age, education, physical functional limitations, and the impact of those limitations on their ability to perform labor both now and in the future. And you'll hear me say that phrase again a little bit later in my discussion, assuming that we get there. We also, you get into the economics, you get into the psychology of it, and something that I'm sure that if you deal with workers' compensation claimants, and if you deal with people that are working on vocational rehabilitation, motivation and psychological factors play major roles, in my opinion, in whether or not people are successful at vocational rehabilitation, they're successful at recovery from work injuries. All the medical studies say that the likelihood of individuals recovering from an injury, if they have a workers' compensation claim, is much less than if their injury occurs somewhere else. And there are lots of different reasons. A big part of it is psychology. A big part of it is economic, because workers' compensation pays benefits. And so people are impacted by the need for, particularly if you have a job that you hate. Then if you have a way out, then you look for it. So one of the things that you would be faced with, if you're not just out there being an expert witness in workers' compensation cases, if you're working what I would call clinically, and you're trying to help somebody to get back to work, is help them overcome some of these other barriers that have maybe not as much to do with the actual injury as they have to do with the fact that daddy, granddaddy, great-granddaddy, and great-great-granddaddy all had workers' compensation back injuries, and they all went off on disability when they were 41 years old. And those are things that you see on a regular basis, and I'm not speaking down about anybody. That's just reality. I mean, every one of these things that I've talked about, I've seen actual cases in which you're dealing with that kind of thing. Workers' compensation is an area of law that is purely statutory. Which means that it doesn't exist but for legislation. There was no such thing as workers' compensation. Thank you very much. They walked me all the way over here real fast. I was running late. I'm old. I'm out of shape, so I have to have water. But anyway, and I talk fast sometimes. So if I'm talking too fast or anything, like I said, feel free to jump in there and ask me a question or raise your hand and say, please slow down. But anyway, workers' compensation is purely statutory. There was no such thing as workers' compensation in the United States until 101 year ago. Last year was the 100th anniversary of workers' compensation in the United States. There was a slight battle going on between the states of Wisconsin and New Jersey as to who was first. Wisconsin had the first constitutional workers' compensation act that was passed. New Jersey was the first state to have a complete workers' compensation act that passed, and it was about 6 months later. Every state now, all 50 states, have a workers' compensation act. Workers' compensation as a concept actually began in Germany. They celebrated the 125th anniversary of workers' compensation in, I guess it was 2 years ago. In Germany. So that was the first place that it started. It's very different than what we have, but that's sort of where the social insurance and workers' compensation. Prior to that, we had what was called master servant liability, which meant that if you were working for Dwight Lowan, Inc., and you got hurt on the job, I only had to take care of you in any way if I'd done something that was wrong. And then you could file suit against me, and if you could prove I was negligent, then I might be responsible to pay you for benefits of some type. But you also had, and I could allege that you had somehow assumed the risk or you were contributory negligent, and if you were, then you got nothing. It was an absolute bar. So the early case law, and there's a reference in the handout that you don't have in front of you, there's a reference to the purpose behind workers' compensation was to place the responsibility for the consequences of work-related injuries and diseases on the industry in which it occurred rather than on the public at large. As I always say, we in the United States I think are good about trying to take care of people who are struggling. So if somebody gets hurt, they still need to feed their family, they still need to clothe their family, still need to provide housing for their family, and so they need some money to survive. And if there's not workers' compensation when you have a workers' comp injury, then they're going to be looking to the Social Security Administration for that. And there's a lot of times there's a blend between the two, and you're going to hear Dr. Crystal was telling me that Sheila Lowther, one of our former administrative law judges, who is now a Social Security administrative law judge, is going to speak to you. Is it tomorrow night or next week? Tomorrow night. And Sheila can give you a really good comparison of how the two systems work, how they interact, and how they're different. But the concept was, if you got hurt at Dwight Lowan, Inc., then Dwight Lowan, Inc. should be the one that's responsible for seeing that your needs are met while you were unable to work. And the first Workers' Compensation Act, for those of you who are Kentuckians, and I know you're not all of you are, even though we're in UK, was in 1914. It was found to be unconstitutional because it did not have a provision that said it was voluntary for injured workers. In Kentucky, in our Constitution, we have a provision that is called the Protection of Jural Rights. That's Jural. In case it shows up on exam, I'm sure it won't, but I don't even know if you do exams at this level. Do you do exams? Okay, yeah, okay. Anyway, that won't be on there. Okay, good. And that basically says that if somebody is responsible for your injury, then you're entitled to full compensation for every aspect of that injury. Workers' compensation does not pay you fully for your injury. It pays based upon a specific formula. It pays part of your income benefit. It pays part of your wage loss, not 100% of your wage loss. Pays part of your medicals, not 100% of your medical. It pays pretty close to 100% of your medicals. So it doesn't pay for pain and suffering, doesn't pay for loss of consortium, doesn't pay for anything other than income benefits, medical benefits, and certain rehabilitation benefits. So in order for it to be constitutional, there had to be a voluntary provision that was added to the act in 1916, and the court found that to be a constitutional act, and we've had a constitutional Workers' Compensation Act in Kentucky since 1916. If you wanted to look at the original 1916 Act with commentary, I have an old book in my office that has that. If you want to look at it, then I'm going to worry about you seriously. There's a reason for me to have it. There's not a reason for you to look at it. But some of the interesting things about it is that there are certain provisions in that statute that are word for word identical to what we have in 2012. Hasn't changed. Lots of things have changed, but not everything. The voluntary provision is very similar to what we have, certain other provisions. So we've had an act since 1916. It is voluntary, sort of, for injured or for workers, employees. It is not voluntary for employers. It is mandatory in Kentucky for employers to provide workers' compensation coverage against any injury that is sustained. The jural rights do not apply on the other side. It doesn't apply to the payor. It only applies to the payee. The only state right now that has a what I would call a voluntary opt-out provision for workers' compensation is Texas. Oklahoma recently took a stab at having an opt-out provision, but it did not pass their legislature. I personally, based upon my years of experience, based upon what I see the purpose of workers' compensation to be, based upon my own personal philosophies, I believe that workers' compensation is a good program, not a perfect program, because you can complain about it whether you're an employer or an employee because it's not perfect. But it generally meets the purpose that's there, which is to place the responsibility for injuries and diseases on the industry where it occurred. Now, workers' compensation is it's one of the first earliest forms of social legislation, precedes Social Security, which of course is a major social legislation in the United States. And it's probably, I'm trying to think, I was a history major in undergraduate school. I'm sure there's some other social program that may have been earlier. I can't think of one right now than workers' compensation. It's also one of the earliest forms of tort reform. If you pay much attention, and you probably don't, but if you pay much attention to different things that go on in the legislature, both at the state level and the federal level, they're always talking about tort reform. We have too many lawsuits. We have all these attorneys, bad people that want to go out and file frivolous lawsuits all over the place. So they're always talking about doing some kind of tort reform. Well, one of the trade-offs in workers' compensation when we made on the social side, workers' compensation is no fault. Doesn't matter who caused the incident. Doesn't matter if the employee did something stupid and got hurt. Doesn't matter if the employee is a jerk and got hurt. It just doesn't matter. And they're entitled to the same benefits. And it doesn't matter whether the employer did anything wrong or not. There's no negligence involved. It is no fault. And the same benefits are paid for the same injury, whether you're the nicest person in the world or whether you're the biggest jerk in the world. It doesn't matter. Good people and bad people both get hurt at work. Workers' compensation doesn't care. So it is social legislation to that extent. The other thing is it provides relatively certain benefits in an expeditious manner. The normal civil case, and as I told you, when I was in private practice, I did civil trial work as well as workers' compensation. Today, once a claim is filed, when I talk about a claim being filed, I'm talking about a litigated claim. Once we receive the litigated claim filing in Frankfurt, from start to finish to a decision by the judge is 180 days or less. If you had that same incident in a car wreck, trying to do it in Fayette Circuit Court, it may take you 2 years to get a trial date, simply because of how civil practice works and how things work and backlogs in the court system. We have 16 judges who are dedicated and have the absolute responsibility to do workers' compensation only. They're not part-time, they're full-time. By statute, they're obligated to render a decision within 60 days of the final hearing. So with those kind of deadlines, it moves through fairly quickly. The amount of benefits is reasonably expeditious. If I know somebody, it's not is reasonably certain. If I know somebody's average weekly wage, I know how old they are, which is only a small part of it. I know their educational background, how many years of school they have, and I know that they're not totally disabled, and I know their impairment rating under the AMA Guides Evaluation of Permanent Impairment 5th edition, then I can tell you exactly how much money they're going to get per week for that disability. And I can do it, and I'll show you in a little bit later how we do that. So that's what the claimant gets. On the defense side, on the employer side, you can't sue your employer. I say that. You can pursue a workers' compensation claim against them, but you can't file suit in Fayette Circuit Court, even if they're negligent. If they work for Dwight Lowan, Inc., and I leave a big hole in the ground and I don't tell them about it and somebody falls in and gets hurt, then the only option that they have is to get workers' compensation benefits. Yes, ma'am. There's no.
There could be like third-party product liability, though.
No. We have, as a matter of fact, there's a case in it was probably 78, because I was at the Court of Appeals, and that they talked about what's called in law, in workers' comp, it's called the dual purpose doctrine. And there was a company up in northern Kentucky that manufactured certain items, and the person that got hurt worked for that company, but they were filing a products liability claim against the company, not a workers' compensation claim against the company. And the court said, no, your only way that you can go against the company when you're working is through workers' compensation. So they can't do that. Now if they were driving down the street and you worked for GM and a wheel fell off a General Motors vehicle, came across the road and hit you, then because you weren't working, you could file suit against them in that kind of situation. But if you are working when you get hurt, and it's as a result of anything your employer did, you can't file a separate action against them, even if it's not based upon just your work activities.
Now, what about a third party?
Okay, a third party, a true third party, that is, I'm on my way over here to talk to Dr. Crystal's class, and it's considered part of my work, or I assume it would be considered part of my work. Maybe it wouldn't be, I don't know. And somebody blasts through the stoplight on Man of War and Versailles Road and T-bones me, and I get hurt, then I can file suit against them. I can still draw my workers' compensation benefits, and I can sue them, the driver of the other car. My employer, Commonwealth of Kentucky, has what are called subrogation rights to try and get back the money that they pay me in workers' compensation from the third party that was liable to them. Then you can get real complicated if I did something wrong, and let's say instead of that, I'm a passenger in a vehicle being operated by another employee, then and they did something wrong, they were driving too fast, and so somebody argues that they were partially at fault, then you get into indemnity benefits and things like that. I still cannot go directly against the Commonwealth of Kentucky, but
It has to be a pure third party.
it has to be a pure third party. If I'm engaged in my working activities, if it's totally separate from work, then that's a different issue. But there's no civil liability, and the benefits. And Kentucky has some states have some provisions that allow you to go against your employer if they were grossly negligent. If they, Kentucky, you can go against your employer if there was an intentional, if they intended to injure you by your actions. And that's pretty strong requirement. Gross negligence generally is not considered intentional. Gross negligence would be something that, we'll use an example of a safety violation. A company over in Blankenship versus Apex Mining, guys operating a bulldozer at a strip mine over in eastern Kentucky, and somebody with management had disabled one of the safety brakes for whatever reason. One never knows why people do different things, presumably thinking that it would help some way in the person doing their job faster. Well, the guy couldn't stop, went down a big incline, flipped the dozer, got hurt badly, and wanted to file a civil action against the employer, and they wouldn't allow him to do so. Now, he was able to, in workers' compensation, you can get an add-on to income benefits if there's an intentional violation of a safety statute or regulation. Intentional being, in that case, if there's not necessarily somebody came in and said, I intentionally did this, but if all the evidence shows that somebody knew about it and let it to continue, then that's an intentional violation. They weren't intending to injure, but they were intending to violate the statute or regulation. and they get an additional 30% of their income benefits.
Let me just briefly go back to the voluntary nature of worker compensation. It's mandatory for the employer to have worker compensation coverage. But when somebody accepts a job, it's voluntary that they accept worker compensation or potential for worker compensation. What have the court said about how they ought to be informed about the voluntary nature
Well,
of
they're,
worker compensation?
they're not to be informed specifically. It's, we have a form, it's called Form 4, and the reason we call it the Form 4 is because it's a little thing up in the corner that says Form 4, and it's the voluntary rejection of the Kentucky Workers' Compensation Act. And if, what's your name? If Krista was working for me and she came in and she said, I don't want to be covered by Kentucky Workers' Compensation Act, and I want to reject the provisions of the act, then I have to provide her, or I have to tell her that she can go to the Department of Workers' Claims or go online and get a copy, or actually you can't go online and get it. We do that because we're not big fans of that. You can call the Department of Workers' Claims. They'll send you a Form 4. You fill out that information that's on the Form 4. You give it to the employer, and the employer has an obligation to send it to us. And so long as you work for that employer and it's sent to us, then you're not covered by the provisions of the Workers' Compensation Act. So if you get hurt, you don't automatically get temporary total disability benefits. You don't automatically get your medicals paid for. But if it's your employer's fault, you have the right to pursue them in a civil case to recover your benefits that way. Some employers have, but certain requirements. Number one, it has to be on file in Frankfurt. It obviously, and I know this sounds very obvious, but you'd be surprised at the things that people try to do. It has to have been in our office before the injury took place. And it has to have been signed before the injury took place. It's not a good idea for the employer to show up at the emergency room and say, sign the Form 4, and then send it to us. The employer cannot require you to refuse coverage. If they do, then it's not voluntary. It has to be a voluntary rejection. And we've had a number of situations, and every one of them the court has said that's not voluntary, where Dwight Lowan tells anybody that comes to work for him, can't afford workers' compensation insurance, so if you're going to work for me, you need to sign a Form 4. And if you want to work bad enough, you'll sign anything. You'll sign something that says you're a rock if you want to work bad enough. And so if you want to work bad enough and I give you a Form 4, you're going to sign it, I'm going to send it in, then you fall off a roof, and first thing I'm going to do, Dwight Lowan Roofing is going to say, they weren't covered, they rejected. Well, that's fine and dandy. Somebody does a little bit of research. Somebody comes to see Dwight Lowan while I'm in private practice. I do a little bit of research, and I see that Dwight Lowan Roofing, everybody that works for Dwight Lowan Roofing has rejected. It doesn't normally work that way. Just by happenstance, you're going to, as much as I'm sure everybody in this room agrees on everything, there's going to be one person in here that doesn't agree. No matter what, there's always one. So the courts have consistently said that's a perfect example of showing that it's not voluntary. If everybody that works there, now if it's one or two people, that's different. But if it's everybody, if you have 10 or 15 people that work there and you're a roofing company in particular or a logging company, then you're probably not going to, it's not voluntary. It's that situation where you want to work, you sign this. That's not voluntary. So right now we have, I think, about 1.2 million employees in Kentucky. I may be off on my numbers a little bit, but or maybe that may be 1.2 million employers and about 2 million employees. Maybe I usually know these numbers, but we have maybe 12,000 Form 4s on file. So, and they're only as, if Krista filled out one when she came to work for me, but then she goes to work for Dr. Crystal, that Form 4 has no impact. Yes, sir.
One of the questions I have is, since Kentucky is an at-will employment state, does the employer have any ability or right to terminate an employee if they fill out that form? Because it's potentially an increased threat on the employer that they could potentially be sued. So what if they just say, I'm going to terminate your employment? Would that be lawful?
There's nothing specific in the Workers' Compensation Act that says that they can't do that. But I would say that that's not lawful, because then anything that impairs a voluntary right under statute, I think there's probably some kind of protection against. That's an interesting thing, because it's, for whatever reason, and as I said, I'm a big believer that workers' compensation is beneficial to both the employee and the employer. There are lots of employers, especially small employers, that think workers' compensation and the obligation to have workers' compensation insurance is a burden. And so I've never had a situation, and I've never even heard of a situation, but that's an interesting question. I'll pose that the next time I'm talking to several of our judges, just to get an idea. But I would say that anything, as I said, I would think that there would be a proscription against it. If, for instance, you came in and you could prove that, and you were trying to get workers' compensation benefits after an injury, then again, it would be the same kind of thing. It would not have been voluntary, because you were trying to reject because you wanted to reject. Then you would be able to do whatever you wanted to do. And, it just doesn't ever happen that way. But yeah, I would say that you can't do that. There's a specific statement in the statute that if an employer, while we are an at-will state, if an employer terminates an employee because they had just because they had a work-related injury, or they filed a workers' compensation claim, or they asserted entitlement to workers' compensation, and you fire them for those reasons, they still get workers' compensation, plus they can pursue you in a separate civil action for actual damages. And that's happened on more than one occasion. And, unfortunately, it probably happens more than we see in the litigation, because some employers can be very subtle and very talented in how they do it. And because we are an at-will state, if they just kind of bide their time and they do it in the right way, they can get rid of somebody. But the fact that you have a workers' compensation injury does not mean that you can't get terminated. As long as you're treated just like every other employee, then, I spoke to a group of, through the federal department, what is it, EEOC, Equal Employment Opportunity Commission. They had a seminar last week out at Keeneland for this area, and I spoke to them about workers' compensation. One of the questions how do they have to, or what do they have to do to terminate somebody that's been injured or has workers' compensation? And, the bottom line is, you have to treat them exactly the same as you'd treat anybody else. And, just because they have a work injury doesn't mean that they get their job back. There's nothing in the workers' compensation law that says that. That's an employment law issue. And then there's the Americans with Disability Act, which, plays a role there. So they're different things. Somebody had another question? Oh, okay.
Let me, while we're on sort of semi-devious practices, what,
Never happened.
what about people who are classified as independent contractors and worker claims?
Right. Okay.
This is kind of jumping ahead.
Yeah, it is. Can I do it? I'll try to address it this way. Kentucky is one of the more stringent states in terms of the requirement for workers' compensation insurance. If you're an employer, then you have to have workers' compensation insurance. An employer is anyone who has an employee. It sounds real simple, but if you hire somebody, and that's a little more, I mean, when you get your handout, you'll see that it says more than that, but the bottom line is, if you hire somebody to do a job and you're going to pay them, then they're your employee under most circumstances. Doesn't matter whether you're hiring them for 1 hour a day, 1 hour a week, 1 hour a month. They're your employee. So that means that you have to have workers' compensation coverage. Yes, ma'am.
What if it's like contracted?
Huh?
If it's contracted?
Depends on that. That's what we're getting to. I mean, you know, it's contracted in the sense, I mean, there's an employment contract. So just the fact that it's contracted, or that you call somebody an independent contractor, or you call somebody contract labor, does not mean they're not an employee. An employee is somebody over whom somebody else controls the detail of the work. They're engaged in the business of the employer. They don't have an independent business of their own. And we have a lot of what we call, rather than saying that we have a lot of issues with independent contractors, the big thing, and it's in every state in the United States right now, when I go to national conferences, there's always a discussion about misclassification of employees. And that's where I hire Krista to be a roofer's helper. And I say, you are a contract laborer. You know, I'm going to pay you X amount. But I'm going to tell you when to be there. I'm going to tell you what roof we're going to do. I'm the one that got the job. You're up there pounding in roofing nails and you fall off the roof. You're not an independent contractor. You're an employee, because I'm the one that controls everything. You know, I can call you whatever I want to call you, but it doesn't mean that that's what you are. So, you know, and even if I get you to sign something that says, I agree, I'm an independent contractor, and I'm going to take care of my own taxes, and you're going to give me a 1099, and I don't expect workers' compensation or whatever. If you're an employee, you're an employee, you're an employee, and the standard is based upon a 9-part test that comes out of a case called Ratliff versus Redmond, and it's a constant battle, particularly in certain industries. Construction industry is a big place, but a lot of people, not a lot, I tend to use hyperbole sometimes. Too many employers attempt to get around the need for workers' compensation by calling the people working for them independent contractors. And because they're giving them a 1099, they say they're an independent contractor. That doesn't mean they're an independent contractor. Even if they call the Kentucky Department of Revenue or the IRS, and the IRS and Department of Revenue say, for tax purposes, you can give them a 1099 and treat them like an independent contractor, doesn't mean they're an independent contractor for workers' compensation purposes. We always go to that 9-part test, and the big controlling factor is control of the details of the work. Not every little thing, but you know, if it requires a specific skill, if you are if I'm a general contractor and I hire you you're a drywall contractor, and I do a subcontract with you to do drywall, then you're probably an independent contractor, because I'm not in the drywall business, I'm in the overall construction business. And you have your own business and you're doing the details of that drywall, and you may be within my larger contract, so you're probably an independent contractor. But if you're working for me as a drywaller, and I'm the drywall company owner, and the fact that you bring your own hammer doesn't mean that you're gonna be an independent contractor, even though I call you that. And I say that, I mean, we've had three instances, one at Kentucky Horse Park, one at a large hospital in Owensboro, one at a school up in Boyd County, where we had exactly that scenario, where we had a drywall company that was calling 50 people independent contractors. And all they're doing is coming in and they're hitting nails into the wall. And to me, that's a big skill because I cannot drive a nail, okay? But in the context of the employment world, that's not the kind of specialized skill that they're talking about. So does that answer your question about the contract? And it deals a little bit with,
Well, I think, many times in like construction businesses, logging businesses, you find employers would prefer to hire people as independent contractors, so it's not just worker compensation, it's all the other benefits that a regular employee would be eligible for that would cost the employer money. So I think they try to get around having to provide those benefits. For example, if an employer has a retirement plan, that has to be offered to all employees. And it may be the wrong way to do it, but if they say you're an independent contractor, they don't have to pay that benefit, a retirement benefit, or health insurance, or other things.
or unemployment insurance. And we just, if you paid attention to this last legislative session, Kentucky's been scrambling like a lot of other states because of the downturn in the economy back in 2008 with the unemployment trust fund being out of money. And they had to borrow money from the federal government. They have to pay it back. And if they don't pay it back in a certain amount of time, then they get this huge multi-million-dollar penalty on top of that. And it comes back on all the other employers. And so it has to be funded. And people who, if they call people independent contractors, they don't have to pay unemployment insurance on them. So it's not just workers' compensation, it's unemployment, it's all these different things. So it is a huge issue, yeah.
The Social Security,
Yeah, right.
unemployment, benefits.
Yeah, and it impact, and I'm sure they're doing, some of them are just doing it because they're lowlifes, in my opinion. Some of them do it because they think that's the only way they can survive in business. And some of them, that may be the only way they can survive in business, is if they try to cut corners. My philosophy, right or wrong, is that if you can't afford to be in business, you shouldn't be in business. But not everybody looks at it that way. I'm all for everybody making as much money as you can make. I can live with that. I don't have a problem with that. But if you can't afford to do it right, then you need to find something else to do. That's just my bottom line. And we have a citation docket once a month because employers, if you're an employer, then you're required to have workers' compensation insurance. As I said, you're going to get it, 4 different ways. You can be part of a self-insurance group. You can be self-insured, but you have to meet very heavy-duty monetary requirements to qualify for self-insurance. You can buy private insurance, Liberty Mutual, Chartis, Zurich, all these big-name companies. I think we have 372 companies that write workers' compensation insurance in Kentucky, or you can get it through KEMI. KEMI is Kentucky Employers Mutual Insurance Company. If you've ever been to a UK basketball game, you see a sign up there that says KEMI. You also see one that says KESA. KESA is a self-insured group on workers' compensation. KEME is what's known as a competitive state fund. It was originally created by statute, but it's now operated like it's not operated like it is operated as a mutual insurance company. And they're the largest writer in Kentucky, in part because under the statute, they have to offer to write coverage for anybody. They're what's known as the insurer of last resort. Now, they're a competitive state fund, so they can insure anybody, then not just the bad actors, but they don't have to insure you for whatever you want to pay them. I mean, they can properly underwrite you, but they have to make sure that anyone can get a policy. If you don't have a policy, then you're subject to getting fined by me, and we have a docket once a month, and we have 10 enforcement officers. We're trying to hire a couple of more that cover the state, and we have somewhere between 75 and 100 employers every month, not the same ones, fortunately, over and over, that we cite, and I have the authority under the statute to fine them $100 to $1,000 per violation. And a violation is considered per employee per day. So if you have 10 employees and you're without workers' compensation for one day, I'm authorized to fine you anywhere from $1,000 to $10,000 for that one day. Now, I don't generally do that, but I do take it very seriously, and what we try to do when we're fining people and citing people is I try to estimate what their workers' compensation premium would have been had they had coverage, and then I tack a little bit on top of that because I want to make sure that no one believes that it's cheaper to get fined than it is to have workers' comp coverage. Now, the other thing that happens if you don't have coverage and somebody gets hurt, they can, in that case, they can get workers' compensation and they can sue you in a civil case. Also, we have what's known as the Uninsured Employers Fund, which is operated by the Attorney General's office. All employers in the state help fund it, but they will pay the injured worker, and they'll turn around and go after the uninsured employer. And when I say go after, I mean they'll put a lien on their house. They'll take everything they can if they have to. And I signed a lien today on some people's property because they didn't have comp coverage and somebody got hurt. So that's why I say it's a big benefit. I mean, people are gambling that no one's going to get hurt. But, I've seen people who are in what seem like innocuous occupations end up being quadriplegics. And you're responsible for all of their medicals associated with that injury for the rest of their life. And for a quadriplegic, that kind of cost is minimum of $1 million a year just to keep them going. Unless you won the $860 million Powerball, most of you can't handle that, me included. And I don't say that, I don't take that lightly because we do. Most workers' comp injuries don't end up with that kind of thing, but quadriplegics, paraplegics, burns, people with really bad burns, a lot of times their medicals will be $1 million within the first month because of all the things that they have to deal with. So, those are fortunately, those are the extremes. But if you don't have comp coverage, then they literally can take everything you have, and doesn't matter if it's a corporation, you can get incorporated, which may protect you in civil liability, but under workers' compensation, they can go after everybody who is an officer and an owner of the corporation to recover those damages. So it's what in the legal field, it's an automatic piercing of the corporate veil. So, everybody that has an ownership interest, they're on the hook for it. So it's pretty strong, as it should be, in my opinion. Yes, ma'am.
Undocumented workers would be covered by workers' comp, wouldn't they?
They are? they're still employees. Yes, ma'am.
When, if someone was off work, say with a back injury, and they were working under the table, say as a painter, just something I would do, and they get hurt again, at a different, and it's worse than before, how does workman's comp handle that type of thing?
It's a pain. It's a real pain. That's all. Yeah. I mean, and we have it both when they're doing it under the table and when they're doing it above the table, where they've had a workers, because the fact that you're getting paid workers' compensation, if you have a permanent partial disability, that means that you're not totally disabled. It means you can go back to work. So you go back to work, you have another back injury, and then you get into the issue of, is this merely an aggravation of your original injury, or is this a new injury? And then frequently you get into the issue, and that from our side, and when I say from our side, from the judicial side, that's where you get into a lot of discussions from doctors, depending on, is it at the, let's say you have a herniated disc at L4 or 5, if you have a re-herniation at L4 or 5, is that really is that a new injury, or is it just an aggravation, exacerbation of the original injury? You know, if it's the same insurance company and the same employer, it's probably not going to turn into a big fight. If it's a different employer and a different insurance company, or if it's the same employer and a different insurance company, then you get into a fight of who pays. Now, if they're doing it under the table, then you have all kinds of complicating factors, because then you get into the fraud issue and that kind of thing, which can, they're still entitled to workers' compensation benefits if they were working, because one of the things where it says an employee, I'm trying to think of the exact, and I should know this, I should have the compact memorized by now, but it basically says whether they were hired legally or illegally. And it's kind of like the undocumented worker. Doesn't matter whether they should have been hired, whether it's legal or illegal. They are an employee. And workers' compensation, you know, my philosophy is I'm in the world of workers' compensation. My obligation is to see that the Workers' Compensation Act is applied equally and fairly based upon what the statute says. There are lots of other issues that are out there that, such as whether or not you should be hiring undocumented workers, whether or not you should be paying people under the table, whether or not you're doing other things that you shouldn't be doing, whether or not you're hiring people to work for you that they're too young to work for you. Those are other issues, and they are important issues, but they're not workers' compensation issues. And I don't mean to sound like I stick my head in the sand. I don't, but I believe that workers' compensation is exactly what it's intended to be, and that's to provide the benefits to the injured people. There have been a lot of states, including Kentucky's taken a stab a couple of times at prohibiting undocumented workers from getting workers' compensation benefits. Well, my belief is all that does is encourages an employer to hire undocumented workers, because if they get hurt, they don't have to pay them, so they can compete better against employers who do get workers' compensation coverage for their employees. So it's flipping the situation from where the real problem is. But that's my belief. And, those are difficult cases because of who's, and they come up regularly, people who have repeat injuries. We had one when I was back on the Workers' Compensation Board doing appeals. As a matter of fact, I think Sheila Lowther, that's going to be talking to you, may have been our chief administrative law judge at the time. The person was receiving total disability, total workers' compensation benefits, they had gone back to work without telling their former employer that they'd gone back to work. They get injured, they file another claim. And the defense was, you can't file another claim because you're getting total occupational disability. So you've already been found to be 100% occupationally disabled. The logic of that is there. I don't have a problem with that logic. But the court said otherwise. The court said they were back at work. So the fact that they didn't do what they were supposed to do by notifying their prior employer doesn't mean they're any less of an employee. Now, they can't get more than 100% occupational disability economically. So what you do is on their second injury, let's say they got hurt in, I'm just going to use rough numbers, but they got hurt in 2011 and total disability benefits are $721 maximum per week, and they were getting total disability based upon 2000 numbers, which may have been $500 a week. So they only get the difference between the two. They're only getting $200 a week. So the maximum they're getting is the maximum for a 2011 total disability. So it's not like they can stack total disabilities, but they can file a new workers' compensation claim.
Well, what I was wondering is if that person was injured more so than they were before, the difference in the amount of coverage that they would get coverage for that injury, would that be covered under the first claim? Or would they just cover to the point that he was injured the first time?
It depends. I mean, and that's one of those where it depends a lot on the mechanism of the injury. If it's something that was a very discrete work event, and maybe they had a 10% impairment from the prior injury, and now they're totally disabled. We have that frequently from a second injury. And it may have been a long time since the first injury, and the doctors testify. You go to Dr. James Bean, a neurosurgeon here in Lexington, who's very good and does a lot of workers' comp cases, and Dr. Bean says, yes, I think this is a new injury, but you're probably, in that kind of case, you're also going to have a very qualified neurosurgeon from somewhere else that's going to say, I think it's a continuation of the original injury. And then then one of our judges is faced with making that decision, and a lot of times it depends on which doctor not a lot of times, it always depends on which doctor they believe, what the other evidence shows. And when I talk about the discrete injury, if I've had a prior back injury and I'm sitting at my desk in Frankfurt and I drop a paper clip and I bend over to pick it up, and my L45 disc goes out again, then that's probably going to be looked at as tied back to my original injury. However, if I'm bending over and trying to lift a 50-pound box and my disc goes out again, then they're probably going to look at that as being a new injury on top, superimposed upon the old injury. And again, you take into account the prior injury when you do the computations.
Something like a back injury also is a situation where people in their everyday lives outside of work will be using their back. And how is that taken into consideration? People Sunday are doing gardening work, or they're up on a ladder, or they're doing lifting, they're doing home projects, and as opposed to a discrete injury such as a crush injury in a machine.
Well, and those are the more difficult cases that our judges deal with, because and the other, we have an aging workforce. I mean, I look at this group and I know that most of y'all are pretty young in here, but we have more people today working that are over the age of 65. Okay, there are a few of you that aren't real young, but, I just figured you might be prematurely gray. That's what I was cutting, yeah. That's kind of like me, But we have more people working over the age of 65 today than we ever have. We have more people over the age of 70 working today than we ever have. One of the things that I've discovered is that getting old is not for sissies. It hurts. There are parts of my body that do not work as well as they did years ago. I can't throw a softball from left field on a line to home base like I used to could. I could probably throw it and it'd get halfway to third base and my shoulder would be dead for a week. But those are the things that are there. But these people are still out there working. There are 70-year-old coal miners that are out there working in 30-inch coal, and they're 70 years old. They have all kinds of arthritis. They have all kinds of degenerative disc disease. They have knees that aren't worth anything. They have hips that aren't worth anything. And, it doesn't take as much for it to hurt me than it does for it to hurt a 25-year-old. It just doesn't. But it doesn't mean that you are any less injured at work. And part of the concept that we deal with is, and they tried to exclude, and it's in our statute, to exclude the effects of the natural aging process, which sounds really good, but in application it's very difficult. Because if I'm out there working in the coal mines every day, and I've been working there for 50 years, every single day, and I'm a hard worker, and certainly I'm a whole lot older than I was 50 years ago, and all of a sudden my back goes out and it doesn't ever come back, and I can't ever go back in the mines. I have no doubt that age played a role, but the employers basically take employees as they find them, and so it was the injury that caused the disability. The injury was superimposed upon a pre-existing dormant, non-disabling condition. It may have been there. They could have taken an x-ray the day before and seen everything, but they didn't take an x-ray the day before. Joe Blow was working the day before and working fine and didn't have a problem. Now, the problem that you get into is when you have the incident on Sunday and then they suddenly get hurt on Monday. You have the incident where deer season opened on Sunday and they fell out of a deer stand on Sunday morning, and then they hold off and they go to the doctor after they report to work and work for an hour on Monday, and then you get into real proof issues. That's a real case, where a guy fell out of a deer stand on Sunday, held off and didn't go to the doctor till Monday after he went to work, and he tried to get workers' comp benefits. But based upon witnesses and some things like that, they found out that happened, and he did not recover. But it's difficult at times, and it's one of the things that our judges regularly have to address, or the difficult cases get resolved. They don't get to the judges usually. Yeah, we're almost done, so that's okay. Yes, sir.
When I used to work out in Winchester, I would be driving down Todd's Road, and I would see a lot of the migrant workers out there cutting tobacco, which is seasonal. And I don't know if they still do it, but years ago, they used to drive a pickup truck, a farmer, right down Main Street, and pick them up on High Street by the truckload and take them out there. They paid them by the bushel, the spear. How does the state handle workers' comp in that particular situation?
There are certain exemptions, certain employers that are exempt from workers' compensation. Not very many, but some. Agriculture is the biggie. Agriculture has been exempted from workers' compensation and is exempted in almost every state. As far as I know, it's exempted in every state since the beginning of workers' compensation. And that was, as I understand it, the reason behind that was to protect the small farms for the most part. Now, there are programs, because I dealt with one in private practice over in western Kentucky, and I'm sure it's up here too, where you have migrant workers who are actually brought in under specific contracts, a specific federal program to do certain activities like cut tobacco, and those farmers are required under the federal program to provide workers' compensation. I mean, it's not our requirement, it's a requirement from the feds that they cover those employees while they're here. And anyone who is exempt, any employer who's exempt from the act can voluntarily choose to come under the act. And there are a number of big farms in Kentucky, because of that issue that I talked about earlier, that they believe that it's safer economically to have workers' compensation than it is to not have workers' compensation. And so they voluntarily provide coverage even though they don't have to. The other exemptions, the big exemptions are anybody that's covered under a federal program. You have Federal Longshore Harbor Workers Act, Jones Act, Railroad Workers, which is FELA, Federal Employers Liability Act. You have Federal Workers' Compensation Act, which is TVA workers, for instance. We have a number of TVA workers down near Paradise Power Plant down in Muhlenberg County, down in western Kentucky. So they're exempt from state workers' compensation because they're covered under a federal program. And then the other one is certain religious groups, but the religious group, to be exempt, has to reject all forms of private insurance. They can't just say, we don't believe in workers' compensation. They don't believe in health insurance. They don't believe in liability insurance. They don't believe in anything. And in Kentucky right now, about the only groups that applies to would be the Amish and the Mennonites. And we don't have as many Mennonites as we once did. But that's how that works. And then, yes, sir.
What about domestic help? Where are you expected to be at a person's house at a certain time every day?
There's an exemption for domestic based upon number of hours and number of people. So if they work less than a combination of 40 hours a week and no more than 2 domestic workers, then they would be exempt from workers' compensation. If I hire somebody to, I love my wife and I'm a lousy housekeeper, and I don't want her to have to do it, and I hire somebody to come in and do it once a week, then we don't have to have workers' compensation on that person.
I'm speaking of every day.
Every day, then you're
Well,
pressing
not
it.
7 days,
Yeah.
but as
Yeah.
though it were a regular job, and instead of going to the factory, they go to the house.
Mm.
Or maybe even live in the house.
Yeah, well, it depends on the hours. I mean, because, for instance, we have probably 5 times a year on that citation docket I talked about, we'll have a situation where you have an elderly person who is still living at home. They've been smart in their investments. They don't ever want to go to a nursing home, so they have 24-hour coverage. And they're paying, they don't hire an agency, they're paying individuals to come in. They should have workers' compensation coverage, because those individuals, they're working basically 24/7, and there's more than 2 of them, and so you have to have workers' comp coverage. And we've run into that on more than one occasion, and it's a very difficult situation for me, because you're sitting there and you're frequently talking to a family member. Most people don't think about that. In all honesty, I would have never thought about it.
But if the person gets hurt, they don't
Absolutely.
have the coverage. The employer doesn't have the coverage, the person that gets hurt can file workers' comp.
Absolutely, yeah. And it's happened. And sometimes that's how we find out that that's even going on. You have somebody that stepped outside for a break and slips on the sidewalk and falls and gets hurt. And I use that as an example because that's one that happened. 24-hour coverage, little lady in Owensboro, her family was paying for it, and they didn't have workers' comp coverage. And she filed a claim against them. And, they're sitting and looking at a citation from me, which is minor compared to the potential exposure that they have both from the estate and from them personally. So those are difficult situations. Yes, ma'am.
So, workman's comp is an all or nothing thing. There's no limited liability that a small employer could purchase that would limit the liability that they would be responsible.
Yeah, I mean, if you buy workers' comp insurance, you're covered, you're protected. If you're a, depending on what kind of business it is, if you have a couple of employees and it's, let's say you do primarily clerical type of activities. I'm just using that as an example. For instance, a small law firm. A small law firm goes buys workers' compensation coverage. It costs them maybe $500 a year. So it's not exorbitant. Now, if you're in the logging business, it's going to cost you a lot more than that because every time they get hurt badly. Or every time they get hurt that they turn it in, I mean, they have a tendency to cut off fingers and not, they just keep on going. They don't turn in claims unless they get really hurt. Same thing with roofers. Roofers, you got falls and you got burns. Those are the two biggies for roofers, and those are bad injuries. So all of that factors into how much the insurance premiums cost. But, purchasing workers' comp coverage, it's not the same. I mean, it varies by business. But that's how if you have insurance coverage, then you're totally protected under workers' comp for any kind of injury that happens. If I have a small law firm and I have two people that work for me and my paralegal runs down the courthouse and gets T-boned by a garbage truck and ends up in a coma for 20 years and I was paying $500 a year and the insurance company has to pay $1 million a year, then it doesn't change. I mean, my premium may be affected for a while, but it's not going to ever be anywhere near what they're going to have to pay. So that's how you limit your liability. You can't do anything. I mean, people have tried to buy disability policies and do other things other than workers' compensation, but it doesn't provide for the payment of temporary total disability benefits, permanent partial disability benefits as set out in the statute, and it doesn't provide for 100% of medicals that are reasonably related to the cure and relief for the effects of the injury. And that's the biggie, more often than not. The medical benefits in Kentucky make up somewhere between, depending on which study you look at, somewhere between 65 and 68 cents of every dollar in workers' compensation in Kentucky. Nationwide, it's more like 59%. We're a little bit high in Kentucky. And I keep saying in Kentucky because one of the things I usually emphasize, and I haven't gone exactly down the way I go, but being statutory, workers' compensation is state-specific. Kentucky's Workers' Compensation Act applies to all those claims that fall under the provisions of the Kentucky Workers' Compensation Act. Indiana has its own Workers' Compensation Act. Ohio has one. As I said, all 50 states have one, and then there's about 6 different workers' comp programs on the federal side. They're not all the same. They're all similar. Well, they're similar in that most of them have some element of income benefits, whether it be temporary total, temporary partial, permanent total, and all of them have some kind of medical benefits that are paid. They are very different, and some of them are very Some of them, like Ohio, which Ohio is what's called a monopolistic state fund, and that's where the state actually not only administers the program like we do, but they collect the premiums and they pay the benefits. In Kentucky, we don't collect and we don't pay. We make sure that the insurance companies collect and pay, but we don't. Ohio does. There are 4 states in the United States that are monopolistic right now. Ohio, Washington, Montana, and Wyoming are the 4 that are monopolistic. Do they work very well?
As compared to private insurers?
Some do, some don't. I mean, West Virginia was monopolistic from when it first enacted an act in 14 or 16, similar to when Kentucky did, and until 2005, and then they went private. There's been a big push the last 2 or 3 rounds in Ohio to get away from monopolistic. A lot of employers think it costs them more. But then, talking to the people that I know in Montana, it works great in Montana. It works great in Washington. Those 2 states, I know some of the people that administer their system out there, and for them, it works great. And the interesting thing about workers' compensation, the interesting thing for me from a enjoying constantly learning standpoint is when I go to national conferences and I'm interacting with people that are in a similar position to me from other states, is the culture in the different states has a huge impact on what works and what doesn't work. The Indiana Act, for instance, most people would consider Indiana to be very I'm trying to think of the right word. Let's just say that if you get hurt and you have the opportunity to file a claim in Indiana or Kentucky, you always want to file in Kentucky, because Indiana doesn't provide very good benefits. But it works in Indiana, and it's been that way for forever. That's what they're accustomed to. If you try to get something like that through the Kentucky legislature, it'd be an interesting time in Frankfurt while that was going on. That's all I would say. We took a huge step back, and I say back, reined in some extremes, I'll put it that way, back in 1996, and we almost had a war over it. But it's worked well since then, and we're still have much more generous benefits than Kentucky does. Than Indiana does. Indiana is probably, if you took the available benefits of the injured worker and you took all 50 states, Indiana would be in the, depending on whether you're looking at it from the worker standpoint or the business standpoint, would be in the bottom 5 or top 5 in terms of the least amount of benefits available to an injured worker. Kentucky would be in the somewhere between 20 and 30 range. At one time we were probably in we were in the opposite 5 of where Indiana was, and that's what brought 96 about. And a lot of that had to do with black lung, which is
Yeah, I was also
I know.
telling about the concept pre-96 of occupational disability, and how the judges or others could consider where a person resided, the age of the person, the education, the employment the person did, much more so than today.
We have 3 kinds of income benefits in Kentucky. We have temporary total disability benefits, permanent partial disability benefits, and permanent total disability benefits. Temporary total are benefits that you receive while you are recovering from the injury, and you haven't reached maximum medical improvement, or you haven't reached a point where you can return to active gainful employment. Not necessarily the same employment, but active gainful employment. Permanent partial disability is paid for a an individual who has a impairment rating under the AMA guides, but is not totally disabled. Someone who's totally disabled is an individual who can't return to work in a competitive economy. And as Dr. Crystal was talking about, prior to 1996, we had what I considered a pure occupational disability standard. Disability is a legal term. Impairment is a medical term. Impairment, cause should not matter. Impact should not matter. If I get my little finger cut off, then and you get your little finger cut off, we have the same amount of impairment. If you are a concert pianist, losing your little finger impacts you. As an attorney, losing my little finger, other than I can't hold it out when I'm drinking tea, it doesn't impact me. It hurts for a little while, but it has no occupational impact. So prior to 1996, I told you earlier, when I was a workers' comp judge or administrative law judge where you're doing the fact finding from 90 to 94, and we had that pure occupational disability standard, and in that you take into consideration the individual's age, education, the physical functional limitations that they have, and the impact of those limitations on their ability to perform labor both now and in the future, taking into consideration their prior experience. So, I could take into consideration that if you have a bad back and you're an underground coal miner and you're working 27-inch coal, which for those of you who don't know anything about underground coal means that you work all day under a coffee table, in essence. Everything you do is in a 27-inch area. That's what working in 27-inch coal means. You're digging coal, you're blasting coal, you're cutting coal, you're moving coal in 27 inches. Now, if you have a back injury and you're trying to do that and you're hauling 50-pound bags of rock dust in 27-inch coal, it's pretty difficult to do. If you're a lawyer, then, other than the need to get up and down regularly, and if you've had back pain, it hurts. That's why they call it pain. But bottom line is it doesn't impact my work in the same way that it does a coal miner. So, I might have that may be an extreme, but, I might have I may have an impairment, but I might actually have no disability. Whereas that underground coal miner, if they're 50 years old, they might be totally disabled. If they're 25 years old, they might be 50% disabled. They may never be able to go back to coal mining. They can go back to some other kind of work, but they're not going to make the same amount of money, and probably not going to have longevity. So, disability takes into consideration those factors. Impairment is purely medical. It should be, and it doesn't always work that way, and the AMA guides over the years has become kind of a blend, in my opinion, from being a pure impairment standard to considering these other factors. But today, for a permanent partial disability, it is 2/3 of your average weekly wage, subject to the state's maximum, 75% of the state's maximum average weekly wage, times the impairment rating under the AMA Guides 5th edition, times the statutory factor, and that's what you get. So it doesn't matter if you're a lawyer or a coal miner. If you both have a 10% impairment and you're not totally disabled, and I always use this example because it's easy mathematically. You have an average weekly wage of $600 a week. You multiply that times 2/3, which is $400, which is less than 75% of the state's average weekly wage. 75% of the state's average weekly wage for 2011 is $500 and some change. So it's under that. So you got $400 as your base. You multiply that times 10%. That's the impairment rating under the AMA guides for back injury with some radiculopathy. And so that works out to $40 a week. then you multiply that times 0.85. And the reason you multiply it times 0.85 is because the statute says you multiply it times 0.85 if it's a 10% impairment. And so you just do. That's $34. So if we can both go back to work, you're an underground coal miner, I'm a lawyer, we both get $34 a week for 425 weeks. Doesn't matter what kind of work we do. Doesn't matter, if you're a student. I mean, we can put them all out there. If we have those same numbers, that's what you get. You get $34 a week for 425 weeks. Why do you get it for 425 weeks? Because statute says you get permanent partial disability benefits for 425 weeks. Now, I wouldn't get it for 425 weeks because all benefits, all income benefits, terminate when you qualify for old age Social Security. And I know I look young, but I'm close enough that I get to old age Social Security before 425 weeks, which is about 8.5 years, expires. 8.25 years, actually. Yes, ma'am. All benefits are, by statute, are paid weekly. You can settle for a lump sum, and usually, a lot of times in our cases, that's the incentive to get a settlement for less than maybe what they were going to pay out over the long haul, because people want a lump sum. If I'm going to get $30, if I'm going to get $30 a week, $30 a week for 425 weeks is not going to do me as much good, probably, as $10,000 in a lump sum. So if they dangle $10,000 in front of my happy face, certainly if I'm an attorney, I'm going to jump on it because, $30 a week, that gets taken out of my wallet by my kids, and they're away at school, and I can still lose $30 a week to them. So, but you can't force a lump sum. There is no way to force a lump sum payment in workers' comp. The income benefits are paid weekly. Total disability, you get it for, that's a partial. Total is 2/3 of your average weekly wage, subject to the state maximum. And so for that same person, if they were totally disabled, they'd get $400 a week until they qualified for old age Social Security, no matter how old they are. And anyway, you don't need to know. There were periods of time where we had lifetime benefits. There were periods of time where we cut off at age 65. So it all depends on the date of injury. There's no cost of living increase. Everything is based upon the date of injury. So it's your average weekly wage at the time of injury. It's the state's average weekly wage at the time of injury. In the stuff that you will eventually get, we have a schedule of weekly benefits which shows what the state's maximum average weekly wage for 2011. An injury in 2011, the maximum you could get is $721.97. So if you happen to be a high wage earner, you're making, let's say you got a really good job and you're making, you're a foreman at a coal mine and you're making $2,100 a week. 2/3 of $2,100 is $1,400, if my math is correct. So that's 2/3 of your average weekly wage. The most you're going to get is $721 a week. So you're less than half of your 2/3 that you're going to get if you're totally disabled. And that's because the statute says the most you can get is the maximum state average weekly wage. So there are circumstances in which high wage earners get burned under this system. There are very few people that can get rich off of workers' compensation benefits, contrary to what some people might think. And I'm not saying that there aren't people that don't game the system. There certainly are, but it's not a place to go. You can make more money working always than you can drawing workers' comp benefits. Yes, ma'am.
And the average weekly rate, range varies per state. Like,
Yeah, it varies, and not every state does it exactly like we do. Some states do it based upon how many dependents you have. It varies based upon dependents. We used to be that way at one time in Kentucky. It was a a base of 55%, and then it was 2.5% for every dependent up to a maximum of 62.5%. So, it varies from state to state, but, and state average weekly wage varies. And some states, they get 100% of the state's average weekly wage. Virginia, for instance, doesn't pay many claims, but they pay a lot more money than we do per claim because they have a different methodology of how they compute their income benefits. So that's another significant difference from state to state, and that's why what I tell you, I focus on workers on Kentucky simply because that's what I deal with on the details. Every state has some kind of income benefits, some kind of medical benefits, and we're dealing with similar issues all over the place. Yes, ma'am.
First of all, is there a statute of limitations to file the original workers' comp claim?
Yes. It's 2 years from the date of injury or the date of the last voluntary income benefit payment. So if you pay temporary total disability benefits, you get 6 months of TTD. Your accident happened on January 1, 2011. They paid you TTD until July 1 of 2011. You would have until July 1 of 2000, well, actually, you'd have until June 30 of 2013 to file your claim. If they didn't pay TTD, or if your benefits were paid under, or the accident happened in another state, even though Kentucky law applies, then it's 2 years from the date of injury. If it's an injury, if it's an occupational disease, it's 3 years from when you know you have the occupational disease and 5 years from when you last were exposed to the hazards of the occupational disease, unless it's radiation or asbestos, and then you have 3 years and 20 years from your last exposure. So, and then there's a couple of 5 years, there's a couple of, AIDS has a longer statute of limitation because, on the occupational disease, because those are diseases that develop sometime after the potential incident, so they're very specific. The difference between an injury and occupational disease, an injury is something that you generally know when the disability initially happened. We all know that. You fall off a ladder, you bend over and pick up something, you suddenly have back pain, somebody hits you in the head, somebody slaps you, things like that. An occupational disease is something that develops over a period of time as a result of your exposure to some type of hazardous element, and you don't really know when the actual condition developed. And Kentucky, the main occupational disease has always been black lung. It's changed substantially over the years. 1993, we had about 8,000 black lung claims filed. In 2011, we had about 130 black lung claims filed. Doesn't mean people are less exposed. It just means the law's changed, the opportunity for benefits have changed, and how we determine who's entitled to benefits has changed. But that's the main one for occupational diseases. Yes, ma'am.
Secondly, are workers' comp benefits taxable?
No. That's part of the reason why you have the 2/3. The 2/3 is to take into consideration the fact that they're non-taxable. The income benefits are non-taxable.
Another question? Bill?
Oh, I just want to know if there's any sort of surveys taken after everything is settled, or is any follow-up formally and informally, or can a person who has maybe a minor grievance but doesn't want to go through the whole appeal process, is there a smooth way they can let your office know that, or maybe they're just happy with it, they want to send a thank you. But if there's just something they feel will be helpful for your office and the legislature as far as future things, so that, or is it just done?
No, yeah. Believe me, I'm always looking for suggestions on how we could do it better.
Where it goes into a database.
Well, it depends on what you're talking about. Every, number one, every employer is supposed to have workers' compensation coverage. Their employer, their insurer is obligated to notify our department that they insure XYZ company. So we have a database on whoever's insured in Kentucky. Every employer that has insurance, we should know about it. If you're injured and you miss more than 1 day of work, then there's an obligation for your employer to notify their insurance company, and then the insurance company has to notify the Department of Workers' Claims. So we have a database that whether they ever pay you anything, because if you only miss 2 days of work, for instance, more than 1 day, if you miss 2 days of work, then they don't have to pay you any income benefits. You have to miss at least a week of work before you get any income benefits. So, you may miss, you may pull your back, miss a couple of days of work, you report it, you don't go to the doctor, you don't do anything, you pop a few Tylenol or ibuprofen or whatever, and you work your way through it. If you miss more than 1 day of work, they have to report it to the Department of Workers' Claims. So we have a database. We average about 40,000 first reports a year. So,
What I was really getting at is the actual individual who has suffered harm, and he's gone through the system. It's just like if I go to Burger King and get a triple whopper or whatever. On the receipt, it's got a little thing I can fill in. And then they got a form you fill out. So I'm speaking of the actual worker who has gone through the system. Is there a way he can have feedback? Is there a mechanism so he can formally say, well, hey, this didn't work out the way I thought it would, or the $25 a week I'm getting, even though it's not a formal appeal, but it's something to let your office know.
yeah, there are a number of different ways. If you want to let our office know, you can go to our website. And, if you're really interested in, I'm sure you are, you can go check our website and find out, as a matter of fact, you can pull up this presentation and several others, but you can go on there, and there's a way that you can communicate to the department through our website, either with your name or anonymously. Good experiences, bad experiences, indifferent experiences, suggestions. We have a group that are called Workers' Compensation Specialists and OMSBuds, and an 800 number, which is 800-554-8601. You can call them 5 days a week. You can access our website anytime and make comments, suggestions, complaints. If you feel like you're being abused, and I don't mean that physically, but if you're being abused by your employer, your attorney if you have one, the others, anybody, you can notify us and we will check it out, I promise you, because a number of those get to me, not every one of those get to me. There's somebody else in the department that checks those on a daily basis. If you have a particular problem that you think you have a good solution to an issue, or you just have a complaint or something good that you want to say, don't hesitate to contact your legislator or write LRC. If you think the law needs to be changed, I can make suggestions, but I can't change the law. The legislature can do that. And we get those regularly too. So, there are a number of different ways that you can do that informally. That's not necessarily going to lead to anything other than us, depending on what it is. If we think that there's an unfair claims practice, for instance, if you report that, the insurance company's 2 months behind on paying your TTD, for instance, then we may go after the insurance company, even if that's not necessarily what you want us to do, because we expect them to do what the statute tells them to do.
We've got about 10 or
I-
15 minutes. Why don't we talk a little bit about the vocational rehabilitation process. And Kristen, you got a question, then we can go
Yeah.
Do
into.
you think that Loveland found claims are underreported due to what you were talking about earlier with employers kind of working their way around the system, pushing them out, or doing what, you know, do you think there's actually more claims than are what are being reported?
Yeah, I would,
Employee,
yeah.
lack of employee knowledge or
right.
lack of employee
I think there probably is, but I don't know that it's substantial. You know, I mean, and I'm talking about statistically substantial. You know, it's probably substantial as it relates to certain specific employers, just like the misclassification issue. We know we have huge problems in roofing and logging and construction and trucking. I mean, there are certain places that you know that you have big problems. Other places, we don't have that big a problem with it. Rehabilitation, which is what y'all do.
Sometimes, just as an aside, sometimes you drive on the highway, and you look at these tractor trailers, and the back of it, it says, you know, drive a truck, be an independent contractor, or something to that effect.
Yeah, exactly. Yeah.
You drive your own, be self-employed, or something.
And some of them are and some of them aren't. You know, it just depends.
But to address Bill's question on another level, a lot of times people don't understand what worker compensation is. They don't
Yeah.
understand the concepts that Mr. Lovin talked about in terms of you can't, you know, get punitive damages. You can't get pain and suffering. You can't, you know, you can't collect things that you can collect in a civil case. And, you know, I understand, people might think, you know, this employer knew that there was this danger, or knew that there was this hazard, they didn't do anything about it, and, you know, they get angry, or just things in general. People, you know, it's like being married sometimes, you know? If you work somewhere for a long time, you know, things happen over the years, good and bad, and then, you know, you get injured, and you think you know, you're not being treated properly. So there are a lot of variables that come into play. And a lot of it is misunderstandings in terms of the grievances, but a lot of it also is, you know, what Mr. Lovin said in terms of, you know, just bad practices on different people's parts.
Yeah, and you're right. I mean, a lot of people have certain beliefs about workers' compensation, what it means and how much it costs and all this, and they simply don't know what they're talking about. And I don't mean that in a mean sort of way, but it's not the most complicated thing you can ever do. But, you know, go take a look at Chapter 342 of the Kentucky Revised Statutes and start reading through it. And, you know, probably after a little while, you're going to think, none of this makes any sense. Or, I mean, just by the way it's written. And so it's not always an easy thing to know. And a lot of times people get their knowledge about what's out there based upon advertisements on TV. Lawyers have become really good about advertising and tell you about all this stuff that you can get and that you can get, and some of it's real and some of it's not. But let's talk about rehabilitation real quick. I know you're ready to roll. I know you're past ready to roll, and that's my fault for being a little bit late, and I apologize. Most workers' compensation statutes have rehabilitation provisions in them. And they vary in terms of their effectiveness. They vary in terms of their usefulness. One of the big positives, I think, of one of the few big positives, in my opinion, of the monopolistic state funds is that they have better control over return to work practices, because we have no influence over return to work. And return to work usually involves some element of vocational rehabilitation. We have provisions, 342-710, which is part of the Workers' Compensation Act, deals with rehabilitation, and it sets out the process that you go through if an individual can't return to either the prior work that they did or the types of work that they did, then they're entitled to rehabilitation benefits. And that's where some of you might come in. And in some states, rehabilitation is very effective. Kentucky, in my opinion, in my many years of being involved in workers' compensation, it has not been very effective in our system. And I don't, and I hope that somebody changes that, and my big belief is that if we can get it out of the litigation process and just get it into pure rehabilitation and not let people think that it's all about whether or not I'm going to reduce my income benefits or I'm going to increase my income benefits, that's a complicating factor. Our judges, on the average, probably order rehabilitation evaluations somewhere between 75 and 100 times per year. We probably average 3 people per year that actually do rehabilitation, vocational rehabilitation, even though the provisions in the statute authorize an acceleration of benefits, which means you can double, instead of getting that $34 a week for 425 weeks, you can speed it up and get it in half that amount of time and get it twice the amount at one time to try to get you through school and get you retrained. In the black lung world, if you have category 1 pneumoconiosis, which is simple pneumoconiosis, and no breathing impairment, then you qualify for what's called RIB benefits, retraining incentive benefits. They pay for your school. They pay X amount of dollars per week for up to 208 weeks while you go to school. And then if you complete a bona fide retraining program, depending on how long that program was, it'll pay you a bonus of $5,000 or $10,000. We've had that program since 1996, and I think 5 people have used it. So something is not working in the vocational rehabilitation world and workers' compensation. We had a period back in the early 90s where voc rehab was mandatory in every case in which an individual was off work for more than 30 days, which was great for people who were in vocational rehabilitation. The unfortunate thing is that they all got dragged into the middle of litigation, and injured workers perceived that somebody was being used to reduce their benefits, and insurance companies perceived that it was just a way to get more money out of them. All of which I think is very unfortunate. That goes back to the thing I said earlier about motivation and the thing that faces you. If I'm a pro quarterback and I have a herniated disc, and they're going to pay me $10 million to come back and work through the pain, then I'm going to be motivated to get back. If I'm an underground coal miner that works in 27-inch coal and they're going to, that's my shut it down call there, then the motivation is much more difficult. It's much more difficult for you to convince that person, if they don't like their job, that you want to help them get back to that job. Or if it's somebody that has a 10th grade education that's been making $75,000 a year, and I'm not picking on underground coal, and I can say all this because both my grandfathers were underground coal miners, and I have the greatest respect. If you've never been in an underground coal mine, take my word for it. You need to respect the people that work down there. But if I have a 10th grade education and I'm making $80,000 a year, there are not very many places that I can have a 10th grade education and make $80,000 a year. So if suddenly I can't go back to coal mining and you tell me that you're going to retrain me where I'm going to make $25,000 a year, to me, that's like telling me I'm totally disabled. Now, part of that's my issue. Part of that's what you have to work with, because you've got the motivational issues that we address. The benefits are there. I've always been a big believer that we're missing the boat on some of these situations where we have very talented people. Now, if they're 58 years old and that's all they've ever done, the odds of you retraining them are not very good. But if they're 38 years old, then there's something else out there that you can help them learn to do. I know we didn't, as I said, I always appreciate the questions, and I'll be happy to sit and take questions for as long as you want. I know, but some of you are ready to roll, and that doesn't mean I'll still sit here and answer questions as long as anybody wants me to, but I fear I long overstayed my welcome. Y'all can take it out on Judge Lowther tomorrow night. Tell her that I took her first hour, and she will tell you that doesn't surprise her. Every time she's ever followed me, she's looked at her watch and said, okay, Lovan took up most of my time, so I won't be here very long. And you can tell her I said that.
Do you have a lot of people with rehabilitation counseling backgrounds working for your offices or any?
We used to have probably 15 people that do rehabilitation. We have one now that it's basically a part-time job for them. I mean, I'm talking about in the Department of Workers' Claims. We're trying to do some other stuff where it'll still come through us, but it's handled through the Department of Education, which I think if we can get it out of workers' comp litigation and put it over in education, I'm hoping that it will be more effective because I still believe that rehabilitation is a huge and important factor, because as I said earlier, you can never get as much money in workers' compensation as you can when you're working. Plus, it's better for you. I mean, all the physicians and all the studies show you that working is better for you than non-working. Yes, ma'am.
And does your office have much to do with policy, or is that just handled through LRC?
The policy?
Policy.
I don't know about I don't know about your definition of much. Yes, we do. A lot of what I do is policy recommendations or responses to questions to LRC, to the governor's office, to individual legislators, to business, to labor groups. So, yeah, and that's one of the reasons why it's worthwhile to periodically go to events that involve other states, so that we're all learn from each other. If Washington State has a good idea, then I want to use it. And I want to use it. I want to recommend that Kentucky use it, because if it's good for them, then it should be good for our people too.
Okay, on that note, why don't we?
Yeah.
I have to go on camera.
Oh,
Is that what I'm being told?
I don't know. No,
Thank you.
I think he's saying shut up and sit down. No, I'm already, not to you, to me.
Me too.
No, I know, yeah. He's saying shut up and sit down? No.
Okay, thank you for being here tonight, and appreciate you sharing with us your knowledge and wisdom. If there are any other questions, then
I'll be here.
be here for a few minutes.
Yeah.
Okay. So,
Thank you. Have a good one.